Hi everyone, I'm Attractive Nuisance. Thanks so much for joining me today as I unpack the US Constitution and its rich history once again. It feels like recently we've been constantly fighting against the system, fighting for our rights, our beliefs, our religion, our autonomy, or just our freedom to live as we choose. And oppression has a way of seeping into every aspect of society, and the struggle for fairness and justice often becomes so ingrained in our lives, especially when the laws aren't just, or they're being used to control people, or when they're just straight up unconstitutional. Which brings me to today's topic, one of Trump's many executive orders that has attracted a lot of scrutiny from social media and politicians. It seems like Trump just can't stop himself from meddling with the US Constitution, which is great for me because it gives me a ton of content to work with, but it's not so great for the country. Regardless, thanks to one of my subscribers, Penne for your thoughts, for leaving a comment to explore such a relevant topic. One day into his administration, Trump signed an executive order that revoked a number of other previous executive orders that were related to DEI, or diversity, equity, and inclusion, and affirmative action. But before we really examine that spicy dish of issues, I really want to give a brief overview of executive orders in the US. And unsurprisingly, the president is granted authority by the Constitution to issue executive orders, so you can kind of see where I'm headed here, because this is a constitutional issue. There are constraints on the use of executive orders that are intended to be the supreme law of the land, but as I will kind of unveil here, there are other issues with that. Broadly speaking, the US Constitution contains three primary premises or branches of authority that has given rise to the separation of powers doctrine in the US. I'm sure many of you are familiar with that term, or at least have heard it a couple times. And the long and short of separation of powers is that there are three branches, and it's the judiciary, executive, and the legislative branches. And each is supposed to remain independent of the other two. The president, as part of the executive branch, is then constrained to the authorities that are outlined for the executive branch, and that lies within Article 2, Section 1 of the Constitution, which is that the executive power shall be vested in a president of the United States of America. Very broad, very vague. This provision is often referred to as the vesting clause because it vests authority or provides or bestows authority in the president and the executive branch. Because of its vagueness, the courts have often struggled to interpret exactly how much authority this actually bestows on the president. While generally speaking, the president only has authority that's granted by or enumerated within the Constitution, or authority granted directly and explicitly by Congress, executive orders have historically been utilized as a kind of loophole to extend presidential powers. They kind of toe the line between constitutional and unconstitutional, and we've seen this previously, and we are seeing it strongly right now. The presidential executive order is derived from the royal prerogative, which I'm not even going to attempt to unwrap that because it's a very complicated, complex issue, and I studied it more in Canada actually, but it is underlying the US as well. Historically, it was a source of almost absolute power for the English king. So if you're a history savant and you want to share your thoughts on English power and the royal prerogative, please leave a comment and let us know how that all works. This leaves a lot of space for presidential discretion, which, as we've seen, can cause massive upheaval and lasting consequences. From my understanding, there are three primary schools of thought for how the vesting clause should be interpreted. One, the president is the sole executor of the executive powers, and he bequeaths authority to the underlying executive bodies, almost as kind of an overseer of the executive branch. The second one is that the president is granted this general power to act in the public interest with specific prohibitions that I'm not going to get into here. The third school of thought is that the vesting clause acts to give the most power to the executive bodies, and then any residual executive power that isn't explicitly given to the executive bodies remains with the president. The courts have, however, agreed on a few areas where the president has exclusive executive power, and these include things like the pardon power for federal offenses, veto power to veto legislation for any reason, and the president can also have full control of the appointment and removal of federal officers. So these powers belong to the president and the president alone, but it's also been decided that the president has virtually unconstrained power to declare war overseas. Absolute power. Very scary. Given that there are these agreed upon powers that only the president has, it's difficult to see a logical argument for finding that the president has all the residual power, since that's not actually an authority conferred by the Constitution.
Because that would be senseless.
But I digress from that for now. Without going too much into the weeds, the major takeaway is that the president does not have absolute power to issue executive orders. In fact, in the seminal Youngstown case, the Supreme Court held that the president can't write any order and just say that it's within one of his actual powers, such as foreign relations, because that's what happened in that case. Is the president at the time passed this executive order and threw in some words related to foreign relations and claimed it was within the executive power. Rather, the president's power must derive from an act of Congress or from the Constitution that explicitly confers authority upon the president. An executive order containing unconstitutional content or effects is almost certainly cause for finding that the president has acted outside of his constitutional authority, especially when it decrees as law policies that are antithetical to the Constitution. So we're seeing that a lot now, and the thesis that I'm really pushing is this. The president has the power to enforce the law as part of the executive branch and not to make the law. But what we've been seeing recently is Trump's tendency and inclination to make the law. I come back to the primary issue that I've really been stressing in this YouTube series, that the changes that are being made by Trump, and in this case it's innumerable executive orders, they can remain in effect until they fall under judicial review, which requires that it's challenged in court, which almost always happens after someone or many someones have already been injured. And then even if the lower courts find that the order is unconstitutional, which they have shown that they're willing to do recently, the case will most likely make its way up to the Supreme Court. And we already know who has a thumb on the Supreme Court decisions. Practically everything, though, that's unconstitutional can be made constitutional if it's found unconstitutional by lower courts. And that's so mind-boggling and not really encouraging or optimistic. Zooming in on Trump's executive order specifically, he titled it Ending Illegal Discrimination and Restoring Merit-Based Opportunity. And we see that Trump used an order to revoke a number of other executive orders. Included in the list of revocations is Executive Order number 11478. It's otherwise known as the Equal Employment Opportunity Order, which was put into effect in 1969 and was intended to promote non-discrimination in the federal government. And part of the order required federal executive departments to have affirmative action programs for their employees, initiatives that Trump has now decreed to be illegal. That is, the verbiage in the executive order is illegal. Framed in that context, Trump's executive order pertaining to the Equal Employment Opportunity Order becomes even more problematic. I'm going to take a brief segue here and indulge myself in a little soapbox appeal and discuss some meritocracy. So meritocracy is, generally speaking, a form of government that bestows economic benefits, political power, and other benefits based on merit and ability. And it promises that the most qualified people will be able to succeed regardless of their identity. And yet, we've seen how real-world meritocracy tends to perpetuate these existing inequalities, and it can really emphasize the disparities that fall between the classes. For example, access to resources, education, opportunities, they're not equal for every person. Not everyone has the same access to those things, so it's easy to say that anyone can succeed based on their merit. The reality is that some groups face greater obstacles to demonstrating their merit and never have a real opportunity to quote-unquote succeed. In an ideal world, then, DEI measures are intended to promote things like access to education in order to bridge the gap between class structures and provide opportunities for historically marginalized groups. So I've been confronted a bunch with this discourse on merit because I've been playing a lot of Portal 2 recently, which kind of explores what it means to succeed, or rather what it means to be doomed to fail. The whole system is rigged to keep our characters trapped in a cycle of pointless tests with no real sense of fairness and opportunity. And if you've played it, you know that the main antagonist in the story kind of goads you along. Regardless of how well you perform in the game or how many challenges you overcome, you just keep doing one after another and another and another, and that's kind of the essence of that game. So it's this guise of merit-based rewards that are concealing the reality of power and control and manipulation that are controlling our decisions. Similarly, while the ideals underlying meritocracy are optimistic and appealing, the practical application of meritocracy in the US operates much differently. In the US, merit is really about pleasing the right people, and it's not about actual competence, and it's in a system that's designed to keep people stuck. So meritocracy sounds great in theory, and it's an especially alluring philosophy of government that might just fulfill that too good to be true phrase. And really, the meritocracy that Trump is proposing is just capitalism dressed up as meritocracy while wearing a hat of dictatorship. So it's a reframing of this American dream that many seek to attain, that if you work hard, you'll succeed. But we know now that the American dream is just that, a dream. It becomes this so-called meritocracy that leaves people behind based on their social standing, and where hard work alone alone simply isn't enough. After all, people like Trump and Musk did not get to the top by their own merits, and they've needed nepotism and family money, exclusive connections to get to where they are. It certainly wasn't Trump's speech and debate skills that helped him become president. More than this, though, the executive order itself reflects some very concerning policy progressions that are being fronted by Trump. The language of the order speaks about non-discrimination policies and how they undermine the traditional American values of hard work, excellence, and individual achievement in favor of an unlawful, corrosive, and pernicious identity-based spoils system. But we know that without non-discrimination policies and legislation, minorities tend to feel the greatest impact. I don't want to digress too far from my topic, so I'm not going to inundate you with vast compilations of statistics because, trust me, there are so many. But those numbers do tend to show that the US actually needs non-discrimination policies and DEI initiatives to attempt to quell the deluge of the rich getting richer. While admittedly DEI may sometimes swing too far, going too far to the side of overt discrimination is certainly more nefarious, and it permits absolute power to money and capitalism. And yet, Trump frames the equal employment opportunity as villainous to distract from the fact that he's stepping far, far beyond his constitutionally allocated executive powers. His order refers to the revoked executive orders as dangerous, demeaning, and immoral race and sex-based preferences under the guise of so-called DEI that can violate the civil rights laws of this nation, prioritizing how people were born instead of what they were capable of doing. But here's the thing, by refusing to acknowledge the systemic racism that's embedded in US history, Trump is doing exactly what he claims to be opposing. He's disregarding the merits of minorities. People of color, women, those with disabilities, non-binary folks, and anyone really who disagrees with the Republican Trump agenda, and he makes it so their voices and abilities are entirely ignored and disregarded by the federal government. And how can we truly uphold the principles of the Constitution, which include fairness, justice, equality, if some people don't even have a fair shot to begin with? So this is just one very clear expression of a policy trend towards Trump's ideal of meritocracy. And it's this notion that people should earn their way to money and power, a system that overwhelmingly favors the rich and the white. And we're seeing more every day. This is leading us down a dangerous path that harms all of us. Let's take a quick breather from the doom and gloom that I tend to evoke. And I want to give a mention to a game that I've been playing recently that brought a much needed spark of joy in these dismal days. It's called Octodad, Dadliest Catch. And it's a cute little indie game. It doesn't take that long to play, but it is so fun. And it's definitely the dumbest, silliest game I have ever played. But its artful story arc and its surprisingly strategic gameplay make it really unnaturally compelling. I have never laughed harder playing a game, and I thoroughly enjoyed my playthrough, so I highly recommend Octodad, Dadliest Catch. I'm really not ashamed to admit, I am an Octodad, and I slayed that game. Well, a game about an octopus that's trying to live a normal life as a dad with $1 million family and white picket fences is utterly preposterous. The changes that Trump has been making are arguably even more ludicrous. Mass signings of executive orders and pushing the US towards a meritocracy threaten to unravel the ideals that are enshrined in the US Constitution. But the most glaring violations of the Constitution here are far more insidious. These unconstitutional policies infringe upon the historical amendments that sought to reduce racism and, more prominently, end slavery. Cue the 14th Amendment. The Equal Protection Clause applies to the states through the 14th Amendment and federally through the 5th Amendment, meaning that government agencies have to treat similarly situated individuals equally. And the application of the Equal Protection Clause distinguishes between 3 classifications, and those are suspect classifications like race or infringing on any fundamental rights. If you want to know more about fundamental rights, you can watch my other video on abortion and fundamental rights that kind of goes into what makes a right fundamental. There are also quasi-suspect classifications like gender, and then there are non-suspect classifications that kind of consumes everything else. When deciding if a classification made by legislators violates the Equal Protection Clause, both the intent of the legislation and the impact of the application of the legislation matter. So again, if you watch that previous video on fundamental rights, I did provide a broad overview of the standards of review that the federal courts use when they analyze state legislation, namely strict scrutiny and rational basis review. So under the Equal Protection Clause, they use strict scrutiny and rational basis review, but there's actually an additional standard of review, and that's intermediate scrutiny. And intermediate scrutiny applies to quasi-suspect classification-based legislation, and it requires that the legislation is substantially related to achieve achieving an important objective. It's that middle ground between strict scrutiny and rational basis review. And so intermediate scrutiny was kind of a way to bridge the gap between the hard line of strict scrutiny and the kind of lackadaisical approach of rational basis. In one case, Justice Ginsburg actually added that they also needed to have an exceedingly persuasive justification for any gender-based government action, but from what I've read, the standard didn't really stick with later sittings of the Supreme Court. That said, under the Equal Protection Clause, the Supreme Court has made special considerations that are specific to affirmative action that tend to make it more difficult to install affirmative action plans, and this kind of ties in with those DEI conversations. In 2023, the Supreme Court decided that affirmative action falls under strict scrutiny instead of intermediate scrutiny. So they created this intermediate scrutiny standard that we are using for affirmative action, but 2023, the Supreme Court said, no, that's not sufficient. We need to have strict scrutiny, which requires that any state legislation's use of race for affirmative action must be narrowly tailored and necessary to achieve a compelling government interest. That's the strict scrutiny standard. While diversity has been decided by the court to be a compelling government interest, the court also held in 2023 that any affirmative action using race must have an endpoint. So the legislation has to specify if it's over in 25 years, 20 years, what have you. It also must have a reasonable, measurable objective with measurable means so that it's clear when it's been attained. And that can be really, really difficult because it's really, really hard to measure racism and how we end racism or reduce and mitigate the systemic nature of racism. That's not something that can easily be accounted for with numbers. So while perhaps a logical constraint that's intended to keep legislators from going too overboard with their classifications and to keep DEI kind of in check, those restrictions make it so much more difficult to establish affirmative actions that meet these stringent standards. And this makes affirmative action so much less desirable, in some cases not even worth the effort. For example, in 2013, the US Supreme Court found that having race as a factor in the school's admissions process, which is one of the most typical ways that affirmative action makes an appearance, it was unconstitutional under strict scrutiny. If they had used intermediate scrutiny, it would likely not have been unconstitutional, but because the court used strict scrutiny, it was unconstitutional. And the school did end up altering its admissions process, and again, it reached the court in 2016, and their affirmative action initiative was actually found constitutional because there was a compelling interest in diversity. The school had articulated concrete and precise goals, and race was made a very insubstantial part of the admissions process. And so this essentially relegated affirmative action to an afterthought, which kind of defeats the purpose of the Equal Protection Clause and dismisses the fact that addressing racism is often far more complex than can be readily articulated in legislation. So because of these constraints, it's already incredibly difficult to enact affirmative action legislation or any DEI initiatives that meet those stringent requirements that the court has laid out. And this greatly reduces the scope of the Equal Protection Clause. So Trump, then in revoking the Equal Employment Opportunity Order, among the others that he listed, he's essentially nullifying the very existence of the Equal Protection Clause. So while the Equal Protection Clause, as part of the 14th Amendment, is a constitutional tenet, and executive orders tend to hold less weight than constitutional findings, Trump's executive orders are beginning to seep into the lifeblood of the US Constitution. And at this rate, Trump's next executive order will probably be something to the effect of, "The Constitution is hereby rewritten to say what I want it to say." Who needs amendments when you can just make it up as you go? Trump's order not only uprooted affirmative action progress, denying the effects of systemic marginalization, but it also served to reinforce this idea of meritocracy, or really the ignoring of differences. And instead of having policies and constitutional questions decided by the court, Trump has effectively asserted that executive agencies can't legally comply with the Equal Protection Clause, but non-compliance with it is unconstitutional. So where does that put us? Exactly where the other constitutional violations put us, which is in the US Supreme Court. And once those questions reach the Supreme Court, questions on fundamental rights, on equality, freedom of speech, on human rights, the Supreme Court could feasibly side with Trump and basically rewrite the Constitution. The violations of rights would become constitutional, Trump would have his absolute power reaffirmed, and the US Constitution would become a figment of the framers' imaginations. So again, I say this is not about the red herring, which in this case is DEI, affirmative action. It's about an entire nation being deprived of their country and of their freedom. Very briefly, I'm going to show you how Canada does equality. So Section 15 of the Charter, which is part of our Constitution, it contains 4 expressions of equality. There's equality before the law, equality under the law, equal protection of the law, and equal benefit of the law. The enumerated grounds that are protected by Section 15 include race, national or ethnic origin, color, religion, sex, age, mental or physical disability. And then there are these analogous grounds, which are just tangents of the enumerated grounds. And they've also been recognized by the Supreme Court of Canada to also be protected under Section 15. These include citizenship, marital status, sexual orientation, and off-reserve residence for Indigenous peoples. This looks very similar to the enumerated versus implied fundamental rights in the US. In 2018, the Supreme Court of Canada articulated that Section 15 is infringed if the challenge law creates a distinction on its face or in its impact on the basis of an enumerated or analogous ground, with the distinction imposing a burden or denying a benefit in a discriminatory manner, and it has the effect of reinforcing, perpetuating, or exacerbating disadvantage. And that is really the key word that the court highlighted in this test, is this disadvantage. A legislative body who creates the law doesn't actually need to intend to cause a disadvantage for Section 15 to be found violated. And the disadvantage element isn't actually restricted to economic disadvantage. It can be really anything if you can kind of show it and prove it to the court. The court also did say that any stereotypes or prejudices and that kind of historical backdrop of discrimination can also be useful in showing disadvantage in a court setting. There's also a test for indirect discrimination, and Canadian courts have recognized that legislation might not openly discriminate, it might not be that obvious. And so for indirect discrimination under Section 15, the emphasis is more on the law's impact. We also have this Section 15 sub-point 2 that protects affirmative action legislation specifically. So a law that creates a distinction on the basis of an enumerated or analogous ground does not violate Section 15 if the law has an ameliorative or remedial purpose, and if the law targets a disadvantaged group identified by the enumerated or analogous grounds. Section 15 sub-point 1 outlines that these enumerated analogous grounds should not create a distinction or change the treatment of someone who fits into those grounds, but subsection 2 highlights that, well, no, in some cases that distinction is actually helpful to remedy historical discrimination. So if that test is met, Section 15 sub-point 2 serves to protect all the distinctions that are created by the law on the enumerated or analogous grounds that serve and are necessary to the remedial purpose. From my perspective, the Canadian approach to equality and affirmative action seemed a lot simpler and more effective. That kind of aligns with what I started to notice while I was studying US and then Canadian law, and it's that Canadian law doesn't seem to cover as many loopholes. It's not as, I don't want to use the word thorough, because it is thorough and concrete and filled out law, but it's not as thorough in that, yeah, we don't cover these loopholes as much. And we generally interpret and apply legislation based on the essence of the law, of what it's trying to say and what it's trying to achieve. And so it's harder to find loopholes in that because it's harder to kind of wiggle through when the essence would be violated by doing so. The mental gymnastics that we see articulated in any US case law, it just doesn't seem as common in Canada. Kind of those obstacles that they overcome in really odd ways when you're reading case law, and it just makes you scratch your head and be like, what is happening with this? We don't have that as much in Canada. We are much more straightforward. The case law reads a lot easier, is what I have found by doing my US and Canadian law. If you notice this difference between Canada and the US, or if you entirely disagree with my perspective, please drop your thoughts in the comments. I'd love to hear your perspective. So the catalyst for this video is Trump's revocation of DEI measures, but it's really not about DEI or diversity or affirmative action. It's about the Constitution and how it's being eroded, one right at a time. These are rights and issues that everyone should be concerned with, or rather, everyone who cares about the US Constitution, personal rights and freedoms, and the US as a country should be concerned with this. This is beyond political discourse. This is a huge issue to everyone. I implore you to care about the irreversible harm that Trump is doing to the Constitution, because no matter what political stance you take or where your moral ideologies fall, the trajectory of the US affects you and impacts the rights and freedoms that are important to you. And I don't think anything could be more personal than that. Thanks for joining me today, and I hope you'll be listening in on more of my content as we all watch the chaos unfold. I'm Attractive Nuisance, and don't forget to like this video, subscribe to my channel Leisurely Law, and leave a comment with your thoughts on what you'd like to see more of. Stay vigilant and fiercely guard our rights.